here in Washington. Former special counsel Jack Smith is testifying behind closed doors to a GOP-led committee investigating his investigation of Donald Trump during his time out of power. Smith is rejecting President Trump's allegations that he was out to get him. In his opening statement obtained by CNN, Smith said, quote, "The basis for those charges rests entirely with President Trump and his actions." Republicans have baselessly claimed Smith was part of a Biden administration conspiracy to target Trump. Now, Trump himself recently called Smith deranged and a criminal. My panel is back, and we are joined now by Caitlin Polantz. What do we know so far about this testimony?
Well, Dana, the biggest headline right now is that he's talking. He's not taking the fifth. He's not declining to answer questions. We know that Smith is responding to questions of the committee. That's notable not just because it's notable to have this former special counsel testifying for the very first time in a setting like this. It's also notable because the knives are out for him, and there's a lot of possibilities where he could walk into a situation where somebody wants to see him criminally prosecuted, whether that's a court, the Justice Department itself. Trump already out there saying he wants to see him behind bars.
Okay, so Jack Smith just went on the record and basically confirmed that Trump would have been headed for prison if he hadn't won the 2024 election. And that absolutely detonates Trump's entire narrative that he was exonerated and that these cases were baseless witch hunts. We're talking about the former special counsel who investigated Trump for trying to overturn the 2020 election, saying in his final report and in sworn testimony to Congress that his office had evidence sufficient to obtain and sustain a conviction against Trump, and that the only reason the prosecution stopped is because of a Justice Department policy that you can't prosecute a sitting president. Think about what that means. Smith is saying the evidence was there. The case was strong enough to win at trial. Trump would have been convicted by a jury and faced criminal punishment, including potential prison time. But winning the presidency gave him protection from prosecution and effectively saved him from going to jail. This isn't some partisan hack making wild accusations. This is a career prosecutor with decades of experience who brought charges based on grand jury indictments and who stood before Congress under oath and said he would make the same charging decisions again based on the evidence. And Smith made it crystal clear. Trump has not been exonerated. Those are his words. Trump has not been exonerated for what Smith calls an unprecedented criminal effort to subvert the 2020 election and obstruct the legitimate transfer of power. That's the prosecutor on the case saying Trump committed crimes and that the evidence could prove it beyond a reasonable doubt. And the only thing that saved Trump from a guilty verdict was winning an election that triggered DOJ policy protections for a sitting president.
Or the Republicans on Capitol Hill. They actually had a deputy previously from Smith's investigation. The man who led the January 6th investigation has already gotten a criminal referral for obstructing Congress, for declining to answer some questions in this investigation. And so the perils that Smith has in how he navigates this interview, he can't decline to answer because he could get a referral like Thomas Windham, another prosecutor on his team, for obstruction of Congress. But then if he gives too much information, there's always the possibility that Congress could accuse him of making a false statement if he says something different than what's in the record or what someone else on his team is testifying to. And then there are court orders and Justice Department restrictions around information from the classified documents case, evidence from the classified documents case against Trump, the volume 2 of the report under seal, and then grand jury secrecy. So much at stake here that even get you to the substance of this.
So here's what Jack Smith said and why it's such a bombshell. In January 2025, Smith released his final report as special counsel. In that report, he wrote that he stands fully behind his decision to charge Trump, and that the admissible evidence would have resulted in a conviction had voters not returned Trump to the White House. The Associated Press covered this extensively, reporting that Smith's findings directly undercut Trump's claims that the cases were politically motivated or based on weak evidence. Smith emphasized that DOJ policy against prosecuting a sitting president is the only reason the case was ended, not any weakness in the evidence or legal theory. That distinction matters. Because Trump and his supporters have been claiming the cases were dropped because prosecutors didn't have the goods, but Smith is saying the opposite. We absolutely had the goods. We just can't prosecute you anymore because you won an election, and DOJ policy says a sitting president can't be prosecuted. So Trump escaped accountability not because he was innocent, but because he won enough votes to put himself behind a procedural shield. That's not how the system is supposed to work, but that's what Smith is describing. Politico also reported on Smith's final findings, and the language Smith used is incredibly direct. He wrote that Trump has not been exonerated for an unprecedented criminal effort to subvert the 2020 election, and that the admissible evidence was sufficient to obtain and sustain a conviction. Then Smith resigned after the case was forced to close because of Trump's election victory. Not exonerated means Trump didn't beat these charges on the merits. He didn't prove innocence. Prosecutors didn't conclude they were wrong. The case was stopped for procedural reasons tied to DOJ policy for sitting presidents, and Smith wants the public to understand that the evidence was strong enough to convict. When a prosecutor says evidence is sufficient to obtain and sustain a conviction, they're not saying this is a close call. They're saying we can win at trial and the conviction can survive the post-trial motions and the appeals process, everything defendants typically throw at it. Smith's point is that this was a trial-ready case, built to hold. And it gets even more damning because Smith didn't just write this in a report. He also testified under oath to Congress about his investigations and findings. The New York Times reported that Congress released a 255-page transcript and nearly 8.5 hours of video from Smith's closed-door deposition in late December 2025. In that testimony, Smith told lawmakers that his inquiry uncovered evidence beyond a reasonable doubt that Trump participated in a criminal conspiracy to reverse the 2020 election results and obstruct the legitimate transfer of power. Beyond a reasonable doubt is the highest standard in criminal law. It's the standard prosecutors must meet to win a conviction. And Smith is saying under oath that his evidence met that standard. Smith also said that while the decision to bring charges was his as special counsel, the basis for the charges rests entirely with Trump and his conduct as alleged in the indictments returned by grand juries. That matters because it pushes back on the claim that this was Smith going rogue or inventing a political case. Smith is saying, grand juries heard evidence and voted to indict, meaning ordinary citizens found probable cause to believe these crimes happened. The BBC also covered Smith's testimony and report, noting that Smith defended the cases and confirmed he would make the same charging decisions based on the evidence, regardless of party. That's significant because one of Trump's main attacks was that this was a partisan prosecution. Smith is saying, I'm a career prosecutor. I brought charges based on evidence and law, not politics. If a Republican did the same things, I'd charge them too. And Smith's willingness to say this, under oath and in an official report, shows he's not backing away. He's not saying, maybe we went too far. He's saying, I was right to bring these charges. The evidence supported them. Trump would have been convicted. And the only reason he wasn't is a DOJ policy that blocks prosecution of sitting presidents. That is the core point. Trump didn't win this case on the merits. He didn't prove the charges were baseless. He didn't convince a jury he was innocent. He won an election that created procedural protection, and that political victory saved him from criminal consequences for conduct Smith says was clearly criminal. And it creates a perverse incentive. Someone accused of serious crimes can try to escape justice by gaining enough political power to sit above the law. Trump understands that dynamic. Why else fight so hard to delay trials until after the election? The strategy was clear. Avoid trial, win the election, trigger DOJ policy, and the prosecution stops. And now the prosecutor who investigated him is effectively confirming that the strategy worked. The political implications heading into the 2026 midterms are massive because Democrats can point to the special counsel himself saying, under oath, that Trump committed crimes and would have been convicted if not for his election victory. That's about as authoritative as it gets. And Republicans are going to have to respond, either by calling Smith biased or by minimizing conduct that a prosecutor describes as criminal. Neither is an easy sell for persuadable voters. Now let's talk about what evidence Smith had and why he was so confident he would have won at trial. The charges in the January 6th case included conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an official proceeding, and conspiracy against rights. Those are serious federal felonies with real prison exposure. Smith brought them based on months of investigation including testimony from Trump's own advisors and White House staff, documents showing Trump's knowledge that he lost, and a detailed timeline of efforts to pressure state officials, organize fake elector slates, and pressure Vice President Pence to reject electoral votes. The indictment obtained from a grand jury laid this out step by step, multiple alleged schemes aimed at overturning the election. And what made Smith confident was the quality and quantity of evidence. We're not talking about vague speculation. Smith had testimony from people close to Trump who said he knew he lost but wanted to stay in power anyway. He had documents showing lawyers telling Trump his fraud claims were false and his schemes were illegal. He had testimony from state officials who described pressure campaigns to find votes or disrupt certification. He had evidence of the fake elector plot, where fraudulent electoral certificates were created in multiple states, and the strategy involved trying to get Pence to treat them as legitimate. And Smith's point is, this evidence was admissible, meaning it could be presented to a jury. He believed it was more than enough to prove beyond a reasonable doubt that Trump committed the charged crimes. NPR also covered the release of Smith's deposition transcript and video, noting that Smith spent hours answering questions from lawmakers about his evidence, legal theories, and charging decisions. Smith explained that the decision to indict was based on standard prosecutorial factors, whether evidence supported the charges and whether prosecution served the public interest, not any political goal or desire to influence an election. That directly undercuts Trump's narrative that this was a coordinated political plot. Smith is framing it as a straightforward criminal case. Another major piece is immunity, and why Smith believed Trump's defenses would fail. Trump's core defense was presidential immunity, the idea that what he did was part of official duties and therefore protected. Smith's team built the case to argue that Trump's actions were private political acts to benefit himself as a candidate, not official presidential duties. The indictment framed Trump as a candidate trying to stay in power, not a president performing constitutional responsibilities. Smith believed that pressuring state officials, organizing fake electors, and trying to stop certification were not official acts protected by immunity. Then the Supreme Court's immunity decision in summer 2024 complicated the landscape by expanding the scope of what can count as protected official conduct. But Smith still believed he could win under that standard, which is why he filed a superseding indictment that refined allegations to focus on private conduct rather than official acts. And the fact that Smith stood by the case even after the immunity ruling, saying he would bring the charges again, signals how confident he was in the evidence and legal theory. This wasn't a prosecutor retreating because the case got harder. This was a prosecutor insisting the case was still solid and trial-worthy. Now about the prison time issue. The charges carried potential sentences ranging from years to potentially decades, depending on counts and sentencing decisions. Federal sentencing guidelines would have provided a range, and a judge would consider factors like seriousness of the offense, the need for deterrence, and the broader harm to democratic governance. Given the gravity, an alleged attempt by a former president to overturn an election, Smith's view is that a conviction could realistically have meant significant prison time. That would have been unprecedented. A former president going to federal prison for conduct connected to an effort to stay in power. But again, DOJ policy meant none of that could happen once Trump became a sitting president. The classified documents case is part of this story too. Smith's report on that case hasn't been released publicly in full. A judge ordered that the second volume, dealing with the Mar-a-Lago documents investigation, remain under seal for now. But Smith indicated publicly that he believed that case was also strong and could have resulted in conviction if prosecution had continued. That case involved allegations of retaining classified national security documents, refusing to return them, obstructing recovery efforts, and misleading lawyers and investigators about what was being kept. In some ways, that's a more straightforward legal case than January 6th, because it doesn't hinge on complex election law issues. It's about document retention and obstruction, well-established crimes with clear legal standards. And Smith's overall message is that Trump was potentially facing conviction and prison exposure in multiple cases, and that legal peril effectively evaporated once he won the election. The political context matters too. Trump and his allies spent months attacking Smith personally, calling him deranged, accusing him of being a Biden operative, and claiming the cases were political persecution. Trump even suggested he would fire Smith and end the investigations if he returned to power. The goal was to poison the well and make the public doubt the legitimacy of the prosecutions. So when Smith writes that Trump has not been exonerated and would have been convicted, he's directly rebutting that narrative and creating a historical record. The investigations were professional, grounded in evidence, and not ended because they were weak, ended because DOJ policy forced them to stop once Trump became president. So why does all of this matter beyond another chapter in Trump's legal drama? Because it goes straight to the rule of law problem. What does it mean when someone can escape criminal prosecution by winning enough political power to sit above the law? The DOJ policy against prosecuting a sitting president exists for reasons: the fear that prosecution could cripple the executive branch, and the belief that impeachment is the constitutional remedy for presidential misconduct. But the policy creates a massive loophole. If you commit crimes and win the presidency before trial, you can freeze prosecution for the duration of your term. And if the crimes involve trying to hold on to power or manipulate elections, the very conduct you're accused of can become part of the pathway to escaping accountability. That is a broken incentive structure. Smith's statements put it in stark relief because he's not saying maybe or possibly. He's saying would have been convicted. That also raises urgent questions. Should DOJ policy change? Should there be exceptions for particularly egregious conduct? Should prosecution be required to resume immediately after a president leaves office? These questions aren't theoretical anymore if prosecutors can document evidence beyond a reasonable doubt and still be blocked purely by the defendant's political success. It also matters because the evidence doesn't just vanish. It sits in government files, preserved. If Trump leaves office and loses the protections of being a sitting president, the legal exposure could return, depending on what future DOJ leadership decides and what courts allow. State cases, like the Georgia election interference prosecution, could also move differently because they aren't governed by DOJ policy about federal prosecution of sitting presidents. Civil cases could use documented facts too, even if criminal prosecution is paused. For Trump's base, none of this will matter. They'll treat Smith's statements as proof of a deep state conspiracy. Trump will frame Smith as bitter and political, and many supporters will accept that because it fits the story they've been told for years. But Trump can't win elections on his base alone. He needs persuadable voters in the middle, and those voters are more likely to be influenced by a career prosecutor, under oath, saying Trump committed crimes and would have been convicted. In close elections, those marginal voters decide control of government. The precedent is also dangerous. If the lesson future presidents learn is that you can commit crimes, delay, win power, and shield yourself, then deterrence collapses. Norms only work when there are consequences for violations. If political success can defeat the legal system, then presidents become functionally above the law as long as they keep power, and that's incompatible with a healthy democracy. There are international implications too. America's credibility depends partly on the idea that rule of law applies to everyone. When a special counsel says a former president committed crimes and would have been convicted but escaped prosecution because he won another election, it signals to the world that America struggles to hold powerful leaders accountable. Adversaries will use that as propaganda. Allies will question stability and reliability. Those reputational costs affect diplomacy, alliances, trade negotiations, everything. Bottom line, Jack Smith's confirmation that Trump would have been convicted if not for winning the 2024 election is a damning indictment of Trump's conduct and the accountability system around the presidency. Smith is saying clearly, Trump committed crimes. The evidence proved it beyond a reasonable doubt. Trump should have faced conviction and potential prison time, but didn't, solely because DOJ policy protects sitting presidents from prosecution. That's not exoneration. It's not vindication. It's a permanent record that Trump escaped accountability through political power rather than innocence. And it will shape the rest of his presidency, influence the 2026 midterms, and force a national reckoning with whether presidential accountability is fundamentally broken when someone can commit crimes serious enough to merit conviction and still avoid consequences by winning enough votes to sit above the law.